Harold, are you there?
Yes, good afternoon, Mr. Chairman. Commissioner Gray is on the line. Could you confirm that you hear me?
What did you say? Yeah, we heard you. Thanks, Harold. I apologize, I couldn't pick up the phone when you called. Gloria? Welcome, everybody, to the Delaware Public Service Commission meeting of December 14th. We have the reading of the meeting minutes of November 30th. Does anyone wish to make any changes or corrections to the proposed meeting minutes? May we have a motion, please?
I move that we adopt the minutes of November 30th.
Second the motion.
Is there any discussion on the motion? Hearing none. All those, Harold, are you in favor?
I have to abstain. I was not present, Mr. Chair.
Okay, that's a valid vote, obviously. Commissioner Correa?
Yeah, aye.
Commissioner Conaway?
Aye.
Commissioner Drexler?
Aye.
And I vote aye as well. The minutes have been accepted. Consent agenda. Is there anything on the consent agenda that anyone wishes to have removed to the regular agenda? If not, may we have a motion on the consent agenda, please?
Move we accept the consent agenda as presented.
I second.
Is there any discussion on the motion? Hearing none, all those in favor, starting with Harold. What's your vote, Harold?
Aye.
Commissioner Correa?
Aye.
Commissioner Conaway?
Aye.
Commissioner Drexler?
Aye.
And I vote aye as well. It carries. Next, we have the regular agenda. The first matter is in the matter of the application of Delmarva Power and Light Company for an increase in electric base rates and miscellaneous tariff charges. We have Mr. Jordan for the company, Mr. Geddes, and Ms. Iori. Mr. Jordan, welcome, and please proceed.
Good afternoon, Chair Winslow. May it please the Commission, Brian Jordan on behalf of Delmarva Power and Light. Before discussing the merits of this, I did want to extend my gratitude to staff for preparing a very smart memo on the topic, as well as to Mr. Geddes for drafting the proposed order in front of the Commission. It is proposed order number 10135, and it follows Delmarva's application, for an EDIT rate change. In plain English, what had happened was that Delmarva had paid more back through its rate refund, which sent an overpayment into the regulatory asset for the EDIT. And so, having realized that misfire, instead of carrying that regulatory asset balance forward for the 5-year EDIT credit, Delmarva applied to transfer that to the 6-year EDIT regulatory liability. And in the application that was filed with the Commission for the electric EDIT on page 2, there is a table that includes and identifies the service classifications that are affected, as well as the effective date for this rate change. And so what you'll see is that the 5 and 6 year EDIT credits for the small general service non-demand and the general service transmission classes would be reset to zero come January 1st, 2023. That the 5-year EDIT credit for the residential and plug-in vehicle and the residential TOU non-demand rate classes would also be reset to zero come January 1, 2023. Further, that any regulatory asset balance from the 5-year EDIT credit for these classes would be transferred to the respective 6-year EDIT liability. Next, that the 5-year EDIT credit for the residential heating rate class be reset to zero effective February 1st, 2023, and that any regulatory asset balance from the 5-year EDIT credit for the residential space heating rate class be transferred to the 6-year EDIT liability. That's what Delmarva is asking for. That's what's included in the proposed order. And with that, I'm happy to take any questions that the commission may have on the topic.
Commissioners, do you have any questions? Mr. Geddes.
Mr. Chairman, members of the commission, as counsel for Delmarva has suggested, you have before you a smart memo from Mr. Baumann. I'm not sure whether it's smart because it's good looking or whether because it's intelligent, but in any event.
Did you use your AI?
That's the problem when you try to make a joke. Anyway, it's a very thorough memo. It sets out in detail what's occurring here and what's being requested. I think Delmarva's counsel has set forth the essence of the application. The staff supports it.
Thank you, Mr. Geddes. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. I also want to thank staff for that memo because, to be honest, I didn't understand the application. I was very confused. So I thank Mr. Bowman for explaining it so thoroughly, and the DPA supports the proposed form of order.
Thank you, Ms. Iori. I believe that's all the parties. Commissioners, any questions at all? Commissioner Correa.
I move that we adopt the order number 10135.
I second.
Commissioner Gray seconds.
For the record, that Commissioner Drexler beat him to it. Any discussion on the motion? Hearing none. Commissioner Gray?
Aye.
Commissioner Correa?
Aye.
Commissioner Conaway?
Aye.
Commissioner Drexler?
Aye.
And I'm an aye. The order is passed. The motion is passed. Thank you. Excuse me. Okay, number 2 is in the matter of the application of Delmarva Power and Light Company for an increase in national gas base rates. We have proposed order number 10136, and Mr. Jordan once again.
Thank you again, Mr. Chair. Brian Jordan on behalf of Delmarva Power and Light Company. And similar to the matter that we just discussed and that the commission approved, this is an application for an EDIT rate change. This, however, is for natural gas. And I want to also extend my thank you to Mr. Geddes for the order and clarify that my comments before were on a well-formatted, intelligent, and most importantly, put into plain English memo from Mr. Bowman. And in front of the commission is order number 10136. And what Delmarva had applied for here was that the 5-year EDIT credit for the residential rate class be reset to zero on January 1st, 2023. That any regulatory asset balance from the 5-year EDIT credit for the residential rate class be transferred to the respective 6-year EDIT liability. Next, that the 6-year EDIT credit for the residential rate class be reset to zero effective January 1st, 2023, and that the combined regulatory asset balance for the 5-year and 6-year EDIT credits for the residential rate class will be addressed in the company's next rate case. I understand that that is also in the proposed order. And with that, if the commission has any questions, I'm happy to answer them. Thank you.
Thank you, Mr. Jordan. Commissioners, any questions of Mr. Jordan? Mr. Geddes?
Mr. Chairman, members of the commission, my only clarification would be that I believe that Ms. Driggins wrote the memo for your consideration. I will refrain from characterizing the memo other than how Mr. Jordan characterized it, and staff supports the form of order that's before you. Thank you.
Thank you, Mr. Geddes. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. The DPA supports the proposed form of order. Thank you.
Thank you. Commissioners, any questions? Commissioner Conaway?
Move that we adopt proposed order number 10136 as presented.
Can we have a second, please?
I'll second the motion.
Thank you. Any discussion on the motion? Hearing none. Commissioner Gray?
Aye.
Commissioner Correa?
Aye.
Commissioner Conaway?
Aye.
Commissioner Drexler?
Aye.
And I vote aye as well. And the motion carries. There was no joshing around on that memo. Number three.
Thank you.
Number three, in the matter of compliance filings for Chesapeake Utilities Corporation regarding the petition of Delaware Division of the Public Advocate to reduce the rates of regulated utilities as a result of the Tax Cuts and Jobs Act of 2070's reduction in corporate income taxes and other tax changes. Proposed order number 10158, and we have, I believe, Summer Pope. Do we have Summer Pope? No, we don't. We have Lindsay Orr right there, right ahead of me, ready to go. Thank you, Ms. Orr.
Thank you, Chair Winslow and Commissioners. Lindsay Orr on behalf of Chesapeake Utilities Corporation. You have in front of you proposed order number 10158, which would approve Chesapeake's requested excess deferred income tax credit, or EDIT, SIR credit rates effective January 1st, 2023. Chesapeake submitted its annual EDIT filing on November 30th, 2022, pursuant to order number 9330 in PSC docket 17-1240. This filing incorporated the audit recommendations of staff's consultant. The new rate would be subject to staff's review and annual reconciliation based on the 12-month period ending October 31st, 2023. Chesapeake thanks staff for preparing the proposed order and allowing Chesapeake the opportunity to comment. The form of order in front of you today incorporates Chesapeake's comments, and we respectfully request that you approve order number 10158. Thank you.
Thank you, Ms. Orr. Commissioners, any questions? Mr. Geddes?
Mr. Chairman, members of the commission, you have before you the proposed order as well as a memorandum from Ms. Gannon that outlines the proposal and the reasons for it. Staff supports the form of order that's before you. Thank you.
Thank you, Mr. Geddes. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. The DPA supports the proposed form of order.
Commissioners, any questions about for the parties? Commissioner Drexler?
I move that we approve order number 10158 as presented.
I second Commissioner Gray.
Any discussion on the motion to approve the order? Hearing none. Commissioner Gray?
Aye.
Commissioner Correa?
Aye.
Commissioner Conaway?
Aye.
Commissioner Drexler?
Aye.
And I vote aye as well. The motion carries. Thank you all. Thank you, Ms. Orr. Number 4 is in the matter of revisions to the rules of practice and procedure of the Delaware Public Service Commission. And we've got proposed order number 10156, and I believe this is Summer Pope's matter.
Yes, thank you, Chairman and Commissioners. Summer Pope on behalf of staff. In PSC docket number 20-0149, order number 9953, the Commission noted staff's recommendation that the Commission should consider adopting rules that incentivize utilities to answer data requests rather than objecting to them or equivocating in their responses. The Commission directed staff to consider the issue revolving around discovery issues at the hearing examiner level and to come up with recommendations to the Commission to expedite those matters so that procedural schedules are not delayed and that the information gets provided to the parties who require it. These proposals should be included in the revised MFRs that staff is currently preparing. So on August 31st, staff petitioned the commission to reopen Reg Docket 99-9, as staff found multiple amendments, including the previously mentioned discovery issue, were necessary. Staff noted 25 amendments, which were detailed in the proposed order today. In order number 10094, the commission approved proposed regulation which contained those amendments, and the amended rules were published in the October 1st, 2022 Register of Regulations. The Administrative Procedures Act, or the APA for short, requires that certain procedures are followed when amending regulations. Section 10118 requires that the opportunity for public comment shall be held open for a minimum of 30 days after the proposal is published in the Register of Regulations, and that the opportunity for public written comment shall be extended for a minimum of 15 days after the final public hearing. Accordingly, staff published notice of the November 2nd, 2022 hearing in the Register of Regulations and 2 newspapers, and that public comment would remain open until November 18th, 2022. Included in the notice was that to be considered at the Public Commission's November 2nd hearing, written materials were to be received by October 14th, 2022. 2 parties submitted written comments, Delmarva and Artesian. The Commission held a public hearing to consider those amendments on November 2nd. In compliance with the APA, which requires that the public comment period remain open for 15 days after a hearing on the proposed regulation, the public comment then remained open until November 18th, 2022. Tidewater, Chesapeake, DPA, and Delmarva submitted public comment by the November 18th, 2022 deadline, which were provided to the Commission for their consideration. Staff reviewed the comments received, and based on those comments, staff made minor changes to the proposed rules in 2 areas. First, in section 2.6.3 and second in 2.6.7, which served to clarify the language. Staff therefore submitted the non-substantive changes to the amended rules as presented in the order today. First, section 2.63 as presented in this order contains a non-substantive change from the amended rules published on October 1st, 2022 in the Register. Delmarva proposed in its comments clarifying language in subsection 2.63, which staff found would be a helpful inclusion to the subsection for all parties involved. This included language which stated that the party responding to interrogatories or data requests is not obligated to provide its response in Word format. Second, section 2.6.7, as presented in this order, contains another non-substantive change from the amended rules published on October 1st, 2022. Artesian proposed in its comments to clarify the form of subsection 2.6.7 to state when the 7 calendar day period begins instead, let me rephrase that. Artesian proposed in its comments to clarify the form of subsection 2.6.7 to state when the 7 calendar day period begins instead of implying when the 7 calendar day period begins. So pursuant to Title 29, Section 10113, any changes in existing regulations to alter style or form or to correct technical errors are exempted from the procedural requirements of Title 29 and may be adopted informally. The non-substantive changes to the regulations as published in October 2022 are therefore exempted from the procedural requirements of the APA and may be adopted informally today as final. Furthermore, an agency's rules of practice and procedure are actually exempted from the procedural requirements of Title 29 and may be adopted informally. And while staff did seek out to proceed down the APA's normal procedure to gather input, staff would like to note it did not have to. So today, staff respectfully requests that the Commission accept those 2 changes to the amended rules and find that these are non-substantive under the APA. Additionally, staff respectfully requests that the Commission ask the Commission to determine that the rules as amended and presented today should be adopted as final for the reasons set forth in the proposed order. If the Commission makes the finding There would be no need to republish the regulation as a new proposal. However, if the commission finds that the changes are substantive, it would start the APA procedure over again. Finally, in preparation for today's meeting, staff sent a copy to the rules as amended, knowing that the registrar would publish it in the Register of Regulations and that the registrar would go over it very closely. The registrar has made some stylistic recommendations, so with your permission, if approved, staff would incorporate those changes received into the copy you will sign today, and which will be sent back to the registrar for publication in the January 1st, 2023 edition. To be clear, it was no substantive change. The change is that the registrar no longer requires a clean copy of the amended regulations to be submitted with an order and amended version. This clean version was presented in the order on the posted agenda as Exhibit B. Accordingly, the registrar recommended that the reference to Exhibit B and the exhibit itself can be eliminated. So respectfully, staff requests that if proposed order 10156 is approved today, that staff may be able to incorporate the changes from the registrar into the copy which you will sign, you would sign today and which would be published. Staff is in agreement with the proposed form of order today and is therefore, for the reasons set forth, in agreement with those changes. Staff thanks the commission for their consideration and the parties for their input.
Thank you, Ms. Pope. Is Ms. Crompton on the phone? Or is Mr. Jordan here for her?
I can address this, Your Honor.
Okay.
Thank you again, Mr. Chair and Commissioners. Brian Jordan on behalf of Delmarva Power and Light Company. And first, I want to thank staff for the opportunity to make comments on this. As staff noted, it was not required, but the opportunity is very much appreciated. Delmarva did submit comments in October, and we incorporate those into the record. And then we issued supplemental comments November 18th, 2022. And the only thing I want to point out there in our supplemental comments is the opposition to the proposed version of 2.6.6. This is the version that would shorten the response time for utilities to respond to data requests. Currently, it's 15 days, including holidays and weekends, and the proposal would eliminate the holiday and weekend. So we would have to count those. Delmarva proposed a 21 calendar day response period. Not that 21 calendar days are always needed, but as an insurance policy, just in case that they were. And in our supplemental comments, what we did was we provided some numbers that I think were pretty eye-opening, at least for me, about some of our previous rate cases and the number of data responses that we've gotten, as an illustration of why 21 days is reasonable. So for example, in docket 20-0150, there are 7 weeks of discovery. Delmarva received 289 data requests that included 688 subparts. In its most recent gas-based rate case, 22-002, for about 6 weeks of discovery, the company received 249 data requests with 477 subparts. And in its last electric-based rate case, docket 20-0149, the amount of written discovery that the company received for 9 weeks of discovery was 338 data requests with 724 subparts. Now, that's not just responding to questions, it's identifying the right person within the company to respond. It's identifying any documents that are responsive to these requests, reviewing any of those answers and documents for any confidential material, as well as doing an attorney-client privilege check. In short, it's a lot of work. And with voluminous written discovery that we receive in rate cases, we are opposed to shortening our response time. As I mentioned, we asked for or proposed an alternative 21-day response period, again, just in case it's needed. And so, in light of these numbers, the company continues to be opposed, along with some of the other utilities in Delaware, to shortening the response period in rate cases to data requests that's proposed in 2.6.6. I appreciate your time, Commissioners, and if you have any questions, I'm certainly happy to answer them. Thank you.
Thank you, Mr. Jordan.
Mr. Chairman, this is Commissioner Gray. Can you hear me?
Yes, sir.
I have a clarifying question for Mr. Jordan, if you would allow it.
Absolutely.
Mr. Jordan, I heard you say the proposal for 21 days. Two questions. Is that specifically a proposal related to rate case proceedings, and within that 21 days, does that include holidays and weekends or exclude them, please?
Yes, thank you, Commissioner Gray. To the first question, the answer is yes, just to rate cases. That's our proposed alternative. I understand that the proposal includes a list of other cases, 215 applications, applications for a certificate of public convenience and necessity, and Delmarva does not oppose or take a position on the response period for those data requests. We are focused specifically on just rate cases, Commissioner. And as for your second question, it would be 21 calendar days, so we would count holidays and weekends in that 21-day period. Thank you.
Thank you very much. Thank you, Mr. Chair.
Ms. Orr?
This is Courtney Emerson on
I'm
behalf
Ms.
of...
Emerson, excuse me.
That's fine. Good afternoon, Chair and Commissioners. I do want to, first off, concur with Mr. Jordan. We had actually submitted the same comments. We do want to just reiterate our concern in the proposed order with shortening that time frame. We had also suggested to keep it with the weekends and holidays excluded to give us that additional time to respond to the very voluminous number of data requests and subparts. In addition, we had submitted comments regarding changing the structure to a rolling data request structure. We presented our concerns with that, both in writing and at the public comment, and we're concerned that those were not included in the proposed order. We do appreciate the language in the proposed order that suggests that we can go to the hearing examiner to get permission to depart from the procedures that are in the new rules, but I do think for all the reasons that Brian stated and that we stated in public comment and written comment, that period should be at least the same, if not extended, and some sort of structure applied to the frequency of data requests.
Thank you, Ms. Emerson.
Chairman Winslow, do I get to speak?
Yes, you do. I was looking, is there any other utility that wishes to speak? That way you could,
Clean it all up?
go ahead then, Ms. Iori.
Thank you, Chairman Winslow and Commissioners. All right, with respect to the 15 calendar days, Delmarva has clarified that they are only asking for it to apply in rate cases. I would point out that the regulations specifically state that the utility, or any party actually, can request the hearing examiner for additional time or for a different structure. And so they have the ability to do that right now. So, and he also said, if needed. Well, that's why that provision is in there. If it's needed, they can ask the hearing examiner. So the change that they would like to make is already encompassed within the proposed regulations. I would also note that other states provide even less time to respond to discovery. And I expect that Delmarva's discovery in Maryland and DC is more voluminous than the discovery that it gets here, notwithstanding how horrible that all sounded. With respect to rolling discovery, I think it's telling that Delmarva, which is the only utility in this state that has had the experience of rolling discovery, didn't object to it, and it's had that experience. Artesian's request to go back to structure, that's what we have now, and that is what is not working. That is why we have, or why staff has proposed the change that it did. I think Mr. Geddes could tell you about the fun that we had in the Delmarva rate case where we had a structured discovery period, and it wound up with us not being able, or with staff, not being able to get the responses to discovery that it needed. That is why we made this change. So I would ask that the commission approve the proposed form of order as submitted. And as noted, the commission really didn't even have to put these out for comments. They are procedural rules only, they are not substantive, and under the APA, the commission could have simply adopted these. Thank you.
Thank you, Ms. Iori. Commissioners, do you have any questions of the parties? Commissioner Conaway?
I move that we adopt proposed order number 10156 as presented.
I second the motion.
Is there any discussion on the motion? Well, I confess that Ms. Iori is correct that when Mr. Jordan describes the quantity and the length and breadth of the discovery requests, it seems a little overwhelming. On the other hand, she also points out the fact that when it gets to be to that sort of a situation that you can easily get an extension of time, I would assume, from the hearing examiner. So I'm going to be supportive of the motion. Commissioner Drexler? Oh, I'm sorry, that's good.
Moved and seconded, correct?
Yes.
Aye.
Commissioner Conaway?
Aye.
Commissioner Correa?
Aye.
Commissioner Gray?
Aye.
The motion carries. Thank you very much, everyone.
Thank you, Commissioners.
Number 5 is in the matter of the regulation establishing the minimum filing requirements for all regulated companies subject to the jurisdiction of the Public Service Commission, and we have Mr. Geddes.
Thank you, Mr. Chairman, members of the commission. This is a similar regulatory docket, although the issues are different. This would be initiating the process to have this go out for publication and to receive comments, appoint a hearing examiner, and to bring whatever changes back before you at some subsequent time. So staff supports the order for your favorable consideration.
Thank you, Mr. Geddes. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. The DPA also supports the proposed form of order. Thank you.
I assume there's no other parties present? Okay. Any questions, Commissioners?
Mr. Chair, Commissioner Gray will move to adopt order number 10155 as submitted.
I second.
Any discussion on the motion? Hearing none, Commissioner Gray?
Point of clarification.
Yes.
Aye.
I was advised by Ms. Pope that there might be some formatting issues similar to the ones that she discussed in the prior docket that might require some changes. Perhaps she could clarify, because I don't think I understood what she said.
Yeah, if I may.
Absolutely.
I sent, or there wasn't a copy sent to the registrar to check for errors and formatting issues prior to being actually sent in for publication, just to
May I
speed it
interrupt
up.
you? May I interrupt you for a second? I understand. So, Commissioner Gray, may we amend the order to be consistent with the other order wherein, I guess, staff can make the appropriate format changes that the registrar is going to require?
Yes. Yes, but I would appreciate if someone in the room could actually make the statement for the record.
I think I just did. Did I miss something? Is the formatting, and what else is?
It would just be formatting to abide by the registrar's manual.
Yes, and I think that's the only change, Harold.
Yes, I will accept that edit to the motion.
And I second.
Is there any further discussion? Commissioner Gray, your vote, please.
Aye.
Commissioner Correa?
Aye.
Commissioner Conaway?
Aye.
Commissioner Drexler?
Aye.
And I vote aye, so proposed order number 10155 has passed. The motion is passed with the change made. Number 6 is in the matter of the request for proposals and the review and approval of any proposed contracts for the purchase of wind-generated renewable energy credits by Delmarva Power and Light Company. And now, do we have Ms. Crompton on the line?
Yes, good afternoon, Chair Winslow. Can everyone hear me?
Yes, ma'am.
Great, thank you. This is Dawn Kurtz-Crompton on behalf of Delmarva Power and Light Company. On the line, I have Jim Jacoby, who is the Senior Manager of Gas Supply and Transportation for Delmarva, in case the Commission has any technical questions about this filing. On June 18, 2014, Exelon, PHI, Delmarva Power, and other related entities filed an application with the Delaware Public Service Commission seeking approval of the proposed merger of Exelon and PHI and the resulting change in control of Delmarva pursuant to 26 Del C 215 and 1016. After significant investigation and discovery, the parties signed an amended settlement agreement dated April 7, 2015. Paragraph 84 of that amended settlement agreement contains a commitment for Delmarva Power to issue competitive requests for proposals, or RFPs, to purchase wind renewable energy credits, or RECs, on commercially reasonable terms in 3 tranches. There were 2 components of the process of complying with the wind RFP commitment set forth in paragraph 84 of the amended settlement agreement, which require Commission approval. First, the Commission would initially approve the RFP for each tranche and review potential approval of any proposed contracts resulting from any of the 3 RFPs as the second step. Today, what I'm addressing is the RFP process for the 3rd tranche. On April 6th of this year, Delmarva filed a request for approval of the Tranche 3 RFP, which was substantively the same as the prior RFP for Tranche 2. By order number 10012, dated April 20th, 2022, the Commission approved Delmarva's application to issue the Tranche 3 RFP. The Tranche 3 RFP was for the term of 2023 to 2024 and was issued by Delmarva Power on May 2nd, 2002. As detailed in the report that was attached to our filing, which is called the Independent Evaluator Report for Delmarva Power's solicitation for wind renewable energy credits, which was prepared by ICF Resources, LLC. I will refer to that as the ICF report. As detailed in the ICF report, no proposed contract for wind RECs was submitted to the Commission as a result of the Tranche 3 RFP, because the RFP did not garner any conforming bids. The ICF report concludes that, quote, Delmarva's 2022 wind REC RFP was fair, competitive, and in compliance with the RFP requirements, including the amended settlement agreement, close quote. As I stated earlier, Delmarva submitted the ICF report to the Commission. It was submitted in this docket on December 5th, 2022. By and through this report, ICF did conclude that the Tranche 3 RFP met the requirements of paragraph 84, but resulted in no compliant bids to fulfill the RFP. As such, based on the information set forth in the December 5 filing, Delmarva submits that the Tranche 3 wind REC process has concluded and confirms that Delmarva will not be submitting a wind REC bid for the Commission's consideration. In conclusion, for all the foregoing reasons, and in accordance with paragraph 84 of the merger commitment, Delmarva respectfully submits that it is in full compliance with paragraph 84 of the amended settlement agreement in docket 14-193 and respectfully requests that the Commission approve order number 10157 as submitted. Thank you.
Thank you, Ms. Kurtz-Crompton. We have Mr. Geddes next, please.
Mr. Chairman, members of the Commission, for all the reasons that Delmarva's counsel cited to you, which I cannot repeat, staff supports the form of order and agrees that they are in compliance with paragraph 84.
Thank you, Mr. Geddes. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. Ditto.
Thank you, Ms. Iori. Commissioners, do you have any questions of the parties? Commissioner Conaway?
I move that we adopt proposed order number 10157 as presented.
I second.
Any discussion on the motion? Commissioner Gray, your vote, please.
Aye.
Commissioner Korea,
Aye.
Conaway,
Aye.
Drexler,
Aye.
aye. The motion carries. Thank you very much, everyone. On the hearing schedule, number 1 is in the matter of the adoption of rules and regulations to implement the provisions of Title 26 Delaware Code, Chapter 10, relating to the creation of a competitive market for retail electric supply service. And we have Ms. Pope to lead it off.
Thank you, Chairman and Commissioners. Summer Pope on behalf of staff. Today is the public hearing on the Commission's proposed regulations relating to community energy facilities, or CEFs. On July 22nd, 2022, the Governor signed into law Senate Bill 298, which amended provisions of Title 26 relating to net energy metering. Commission staff drafted comments to the Commission's rules for certification and regulation of electric suppliers, also referred to as supplier rules, which are in Title 26 of the Administrative Code, Section 3001, in compliance with the new requirements set forth by Senate Bill 298. Staff recommended that the Commission issue the proposed amendments to the supplier rules for publication. On October 12, 2022, in Order Number 10109, the Commission approved a proposed regulation, and the proposed regulations were published in the November 2022 Delaware Register of Regulations. In accordance with the APA, staff published notice of this proceeding in the Register of Regulations and 2 newspapers. To be considered at today's hearings, written materials were to be submitted by November 28, 2022. The Division of the Public Advocate and Delmarva Power and Light each submitted comments on the proposed regulations on November 28, 2022. As noted in the Commission's Order Number 10109, the Commission must leave the public comment open for an additional 15 days following this hearing in accordance with the APA. Therefore, public comment will remain open until November 29th, 2022, and the Commission's final decision on these amendments will not be made until after such period expires. Therefore, the Commission will be making no decisions today, but will consider the public comments received by November 28th and any additional public comments on the matter today, should there be any. So again, for your consideration are the written comments received by the DPA on November 28th and Delmarva on November 28th. Accordingly, I will, for the time being, defer to the parties to speak on their own written comments.
Thank you, Ms. Pope. Dawn, are you there still?
Yes, Your Honor. Dawn Kurtz-Crompton on behalf of Delmarva Power and Light Company. Thank you for allowing us to be heard in this matter. As stated in our initial comments, Delmarva Power thanks staff for preparing the proposed NEM regulations and generally supports the proposed regulations. We would, however, like to focus our initial comments on one critical issue that pertains to timing for implementation. As this commission may be aware, Delmarva Power has actively participated in Senator Hansen's energy stakeholder meetings since 2021. During those meetings, Delaware utilities, solar advocates, environmentalists, staff, and the DPA, as well as other stakeholders, engaged in robust discussion with Senator Hansen to consider and debate various pieces of legislation, including the 2021 amendments to community solar, which was Senate Bill 2, as well as revisions to certain sections of the net energy metering statute, which is Senate Bill 298. With respect to the discussions concerning Senate Bill 298, Delmarva advised all stakeholders that if the bill passed during 2022, that any related billing system upgrades would be highly complex, and that due to the long lead times for complex IT projects that are already in the queue at Delmarva, such changes would only be feasible at the end of 2023. This practical constraint was raised several times during the energy stakeholders meetings and in email exchanges thereafter. Delmarva Power also reiterated these timing constraints regarding the proposed NEM regulations during discussions with staff, DPA, as well as with Senator Hansen and Senate Attorney Frank Murphy. Accordingly, Delmarva has proposed certain language that would expressly memorialize that certain facets of Senate Bill 298 would be effectuated at the end of 2023. As set forth in our comments, we proposed certain changes to effectuate that in section 15.3.1, as well as in section 15.3.2. We appreciate the Commission, staff, and DPA's consideration of these changes, and we ask that these additions be permitted to the regulations so that this unavoidable practical constraint can be addressed in these regulations without further need for legislative change or a request for a waiver or anything of that nature. I thank the Commission and staff and DPA for their consideration, and I'm available if there are any questions. Thank you.
Thank you, Ms. Crompton. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. First, I want to point out that this, what we're dealing with here, does not address community energy facilities. This is solely on net metering. I think we are done with community energy facilities, at least for the time being. The DPA also thanks staff for drafting the proposed amendments to the regulations that would implement the amendments to Section 1014 that the General Assembly passed and the Governor signed on July 22nd, 2022. The DPA does not propose any changes to the regulations. We simply had a question about one of them, which has been answered to our satisfaction. So we urge the Commission to approve the regulations as final, realizing that you have to leave the record open for 15 days after this. Delmarva seeks to add language to the regulations that would change what the General Assembly intended. Basically, through this change, Delmarva seeks to postpone when the changes that the General Assembly made to Section 1014 would become operative. Now, I'm handing you or Mr. Slater is handing you a copy of Senate Bill 298, which are the amendments to Section 1014. And I would direct your attention to subsection E1B. Now there, the General Assembly specifically laid out how excess KWH credits were to be calculated. And it says, for commission-regulated utilities for existing and future net energy metering customers, both residential and non-residential, the monthly excess KWH credit shall be valued at the sum of the volumetric KWH and components of the supply service charges and distribution service charges, not including the charges for societal benefits programs, according to each participating customer account's rate schedule. At the end of the annualized billing period, a customer may request a payment from the electric supplier or any excess KWH credits. The payment shall be calculated by multiplying the excess KWH credits by the customer's supply service rate. Such payments, if less than $25, may be credited to the customer's account through monthly billing. Any excess KWH credits shall not reduce any fixed monthly customer charges imposed by the electric supplier distribution company. The customer generator retains ownership of all renewable energy credits, RECS, associated with electric energy produced unless the customer has relinquished such ownership by contractual agreement with a third party or by other means. And then it goes on to define societal benefits programs. There are two things that you should note there. One, the calculation does not include any discussion of weighted averages or a number of billing periods, as one of Delmarva's proposed changes does. Two, there is no postponement until the end of 2023 or the beginning of 2024 as to when these requirements are to take effect. Delmarva is asking this commission to make changes to the statute through its regulations. What it's essentially proposing is an end run around the statutory requirements, and the Commission cannot do this. Now, Delmarva doesn't cite any authority for its proposals, probably because it can't, which I'll get into a little later. What Delmarva claims in support of its proposals is that its need for this time was discussed during Senator Hansen's energy forums, and it may very well have been discussed, but Delmarva helped draft the legislation, and guess what? Its practical constraint didn't make it into the legislation. And I would remind the Commission that when I was arguing about what took place in Senator Hansen's forums with respect to community solar regulations, I was told that, quote, quite frankly, whatever happened in the forum, I don't think is part of the record, and I don't think we should bother to consider it, quite candidly, end quote. That is from pages 1062 to 1063 of the March 16th, 2022 transcript. If what happened in the forums wasn't relevant or part of the record for purposes of the community solar regulations, then it isn't relevant or part of the record for these net metering regulations either, and the Commission shouldn't bother to consider it. Now on to the legal issues raised by Delmarva's proposed additions to the net metering regulations. Delmarva's additions change the way in which the excess credit is calculated in Section 15.3.1, and when the changes enacted by the General Assembly will become operative in both Sections 15.3.1 and 15.3.2. And as I previously noted, Delmarva cites no authority for its proposed changes, which, if adopted by this Commission, would essentially amend the statute. The case law is clear that, quote, a public administrative agency such as the Commission may not adopt and promulgate rules and regulations which are inconsistent with the provisions of a statute, particularly with a statute which it is administering or which created the agency, end quote. Furthermore, quote, legislation, however, may not be enacted under the guise of its exercise by adopting a rule or regulation which is out of harmony with, or which alters, extends, or limits the act, or which is inconsistent with the clear legislative intent as therein expressed, end quote. That is from the Wilmington Country Club versus Delaware Liquor Commission case from 1952. It may be old, but it is still good law. Starting with Delmarva's addition of the following language, quote, the payment for residential customer accounts shall be calculated by multiplying the excess KWH credits by the customer's supply service charges based on a weighted average of the first block of the summer, paren, June through September, end paren, and winter supply service charges, paren, October through May, end paren, in effect at the end of the customer's annualized billing period and the preceding 11 billing periods, excluding non-volumetric charges such as the transmission capacity charge and/or demand charges. Go back and look at Senate Bill 298. The General Assembly did not distinguish between residential and non-residential customers regarding how excess KWH credits would be calculated. Rather, Senate Bill 298 says, for commission-regulated utilities for existing and future net energy metering customers, both residential and non-residential, the monthly excess KWH credit shall be valued at the sum of the volumetric KWH components of the supply service charges and distribution service charges, not including the charges for societal benefits programs, according to each participating customer account's rate schedule. Section 15.3.1, as drafted by staff, simply restates that statutory language. Approving Delmarva's proposed additions to Section 15.3.1 would be adding language to the regulations that is not in the statute. With respect to Delmarva's proposed postponements of the operative date of the statute to December 2023 and January 2024, the Commission should also reject those proposed postponements. Again, Delmarva is adding language to the statute that the General Assembly didn't see fit to put in. The general rule is that, quote, where there exists no controlling constitutional or general statutory provision, as is true in Delaware, the authorities support the proposition that an act takes effect immediately upon its approval by the governor unless the legislature has manifested a contrary intention in the act itself, end quote. That is from the Supreme Court's opinion in Conway versus Wolf Liquor Company from 1964. It too is an old case, but it too is still good law. Nothing in Senate Bill 298 indicates that its operative date is different from its effective date, as would be necessary for the Commission to postpone implementation until 2023 or 2024. The effective date of Senate Bill 298 was July 22, 2022, when the governor signed it into law. And because the General Assembly did not specify a different operative date, that is, the General Assembly expressed no contrary intent, that means the effective date and operative date of the amendments are the same, and the Commission is bound by that. The General Assembly could have postponed the operative date of the amendments. It has done so before, and I would point you to sections 1006 and 1007 of the Restructuring Act as examples. But it didn't do so here, regardless of Delmarva's claim that the issue was discussed in the forums. If the General Assembly had wanted to give the Commission authority to depart from statutory provisions, it would have said so. For example, in Section 102A, the General Assembly specifically authorized the Commission to depart from the provisions of the APA with respect to public notice. And in Section 306A1, the Commission gave the Commission the ability to take more than 7 months to decide a rate case. This Commission has also recognized previously that it cannot go beyond what the statute authorizes it to do. For example, in docket numbers 21-0408 and 21-0409, which involved two Delmarva DSIC applications, Delmarva sought the Commission's approval to ignore statutory language regarding how and whether under and over collections are recovered. In the electric DSIC, Delmarva had over-recovered as a result of a miscalculation and sought to return the over-recovery to ratepayers in a different manner than the statute provided. In the gas DSIC, Delmarva sought to include a 2020 DSIC period under collection of approximately $200,000 that had not been included in its base rate case when its DSIC was reset to zero. The Commission rejected both of Delmarva's requests, finding that the statutory language did not allow it to do what Delmarva was asking it to do. The language of Senate Bill 298 likewise does not allow the Commission to do what Delmarva is asking it to do here. Delmarva's remedy is to go to the General Assembly and try to get the law changed. We understand why it might not want to do that. It's certainly a more difficult road to hoe. But that is its remedy, not this Commission changing the law. Thank you.
Thank you, Ms. Iori. Ms. Crompton?
Thank you, Your Honor. I will keep my comments brief. This wrinkle has already been an enormous strain on resources for Delmarva, clearly based on Ms. Iori's recitation. The DPA has put significant work behind this as well. And as Ms. Iori stated, there is another remedy that is available. We do believe it is proper for the Commission to effectuate legislative intent, and we do believe that there was the legislative intent behind this, but we recognize that if this is not accepted or permissible by the Commission, as stated earlier, we will take alternate action, either via seeking a waiver or approaching Senator Hansen and Mr. Frank Murphy with respect to changes to the statute itself. If that's the road that we have to hoe, then we will go that way, but I would just like to state again that this has been an enormous strain on resources, and we're looking forward to closing down this issue. Thank you.
Thank you, Ms. Craig.
I would simply note it's been a drain on a lot of people's resources, not just Delmarva's.
I think she recognized that in her comments. Commissioners, do you have any questions of the parties?
I think so.
If I may.
Oh, yes, I'm sorry, Ms. Pope. Go ahead.
That's
Mr.
okay.
Chairman, this is Commissioner Gray. I think Ms. Iori's argument resonates quite well and clearly with me. On the other hand, I'm just curious, and maybe it's a rhetorical question, but if Delmarva does not implement according to the statutory intent the way it currently is written, does this commission engage in any way to assert its administrative authority in that particular scenario, or is that a question that we should just put to the side right now?
Well, first of all, I don't think Delmarva would go without taking any action whatsoever, depending upon what our decision is. And secondly, I don't think that's a question that's, in my opinion anyway, that we should discuss now, because it's just not on the table right now.
Okay, thank you. That's a fair response. Thank you, sir.
I don't mean to usurp all the answers to that question. If Ms. Pope, I know, has something else to say. Ms. Iori, you want to add to that? Okay. Ms. Pope?
Thank you, Commissioners. Staff would agree with the DPA's comments, and perhaps it's worth going over a little bit more background for this. As the Commission is aware, the Public Service Commission is an administrative agency. And the Superior Court have found that agencies adopt regulations which affect similar areas to those addressed by legislation, as long as they do not conflict with the law passed by the General Assembly. An agency's regulations as adopted should give effect to the intent of the legislative body. This is settled case law seen as most recently as in Jennings versus the City of Seaford in 2022. As a result, when there is a conflict between a statute and the regulation, the statute will always prevail. Put simply, the Public Service Commission's regulations are junior to state statutes, so in regards to Delmarva's comments, it's staff positions that our regulations, as amended, cannot conflict with the statute. And because of this, staff does not agree with Delmarva's proposed amendments to Reg 49, specifically 15.3.1 and Section 15.3.2, because as proposed, Delmarva's regulations conflict with the Delaware state statute. The intent of the legislative body was so the provisions contained in Senate Bill 298 became effective on July 22nd, 2022. However, as proposed, and Ms. Iori already stated, Delmarva pushed the effective date back to in sections 15.3.1 and sections 15.3.2 up to January 2022, or 24, excuse me. Staff is unaware of any source which suggests that the Senate Bill 298 did not go into effect on July 22nd, 2022, and is unaware of another source which permits an effective date to go into effect at another date. Instead, it is staff's position that because there is no explicit mention as to the date and the provisions in Senate Bill 298 went into effect, that the effective date is, in fact, July 22nd, 2022. As a result, this would mean the provisions are already in effect, and to adopt a regulation which stated otherwise would be in conflict with the state statute. Further, the billing issue upgrades and how to proceed, as the chairman already noted, should be decided at a later date in a separate matter. Today's hearing is in regards to Reg 49 and its proposed amendments. So today, the commission only has to consider the written comments received prior to November 28th, 2022, and any public comments received today. At the next commission meeting, which I believe will be the second week of January 2023, the public comment period will have closed, and the commission will then be able to consider all comments received on the matter before making their decision. The questions of next steps and procedure regarding the inability to meet the statutory requirement and perhaps a regulatory requirement is respectfully not before the commission at this time, and the discussion of procedure should be addressed if and when it comes up in a separate matter. Staff would like to thank the parties, Delmarva and the DPA, for their input, and thanks the commission for their time. And I would just note that this is a hearing, so public comment should be requested today. Thank you.
Thank you, Ms. Pope. Is there anyone from the public here to make any public comment on this matter? Is there anybody on the telephone that wishes to make public comment on this matter? Is there any commissioner that has a further question about this matter? I heard no responses to my request for a public comment. Commissioner Drexler?
I would move that we approve the adoption.
Excuse me, there's nothing to,
No.
Okay, so
sorry,
we
no
just- we're
decisions
not
will be
even-
made today,
just-
so, yeah, so you'll just be considering them today. Thank you.
Okay, so we're all set. I think, is there anybody here other than this particular matter we just heard who wishes to make public comment to the Public Service Commission? Mr. Hardigan.
Thanks, Chairman Winslow. Under Director's comments today, we do have two items. The first is an ask from staff to the commission regarding a grant application from Delmarva concerning the Infrastructure Investment and Jobs Act. As you know, the IIJA allows utilities to apply for grants for certain infrastructure-related projects. The process is broken down into two steps. So by this Friday, Delmarva has to submit a concept paper to the Department of Energy, and then in next April, a full-blown application. But the company has indicated it would be helpful to indicate the Commission's approval for them pursuing this grant. Staff believes that would be helpful because the company has indicated that any money received through the grant would offset expenses that the company would incur otherwise for infrastructure projects. So I would ask that the Commission authorize the company including or signaling their approval in the grant concept paper.
Thank you, Mr. Hardigan. Commissioners, do you have any comments or you have any questions of Mr. Hardigan on that particular issue?
This is Commissioner Gray. Mr. Hardigan, thank you. Do we get any indication of scope of interest for the grant or area in which the application will be submitted? And is the approval today to seek the grant an endorsement for whatever detailed grant is to be submitted at a later date? Or do we get another shot at the apple, if you will?
Commissioner Gray, I believe that any infrastructure that Delmarva Power puts in the future will meet with a steady eye from Mr. Slater's office and staff's scrutiny and come before us for approval or rejection or whatever we might decide. I think that the form of order or the motion we make would be to, I guess, basically to request and support that the money requested by Delmarva Power and Light be approved, but obviously we're not going to give up as part of that motion our right to, by item, review their future requests for capital or operational monies.
Mr. Chair, you're breaking up a little, so if I'm interrupting, I apologize, but I'm completely in favor, and I would certainly make a motion to for the commission to agree that Delmarva should seek whatever possible grant monies are available and appropriate for infrastructure from the Infrastructure and Jobs Act. That would be my motion.
And
to
that
approve it.
we support their application.
And
Yes.
I would second that motion.
Is there any further discussion on the motion? Commissioner Gray, your vote? Commissioner Gray?
Aye.
Commissioner Correa?
Aye.
Commissioner Conaway?
Aye.
Commissioner Drexler?
Aye.
And I vote aye as well. Mr. Hardigan?
Thanks, Chairman Winslow. The second item,
Sorry, Mr. Hardigan, this is Commissioner Gray. I apologize for interrupting again. Mr. Chair, may I have the floor for just 30 seconds, please, before Mr. Hardigan goes to his next item?
You can have the floor for as long as you want it, as long as it's not too much in excess of 30 seconds.
Sorry. So My intent was to come to the meeting physically today, but my automobile told me that I had a tire issue, so I circled back to Wilmington. I just want to take a moment and say my sincere thanks and appreciation to everyone who has expressed sentiments, sorrows, and the painfulness in the recent death of my wife. It was quite a sudden incident of exposure to pneumonia, and she succumbed on the 14th of November quite suddenly. It has been an enormous amount of love that has come my way and support for which I'm specifically grateful. And I know that my colleagues, as well as the folks with whom I work around and with the commission, have also expressed their concern as well as their sorrow. I'm managing it so far. It's painful. I miss her, of course, but it apparently was her time to go. And God knew a remarkable angel that he could call back into his company, because for me, she was remarkable for 55 years together and 51 years married. So I thank you again, everyone, for all of your sentiments, all of your support. I do want to wish everyone a safe and enjoyable holiday season as it's coming upon us. But I just, Mr. Chairman, wanted to express my appreciation. Thank you very much for the time.
And Commissioner Gray, thank you so much for your words, and obviously we send our best wishes and our love and our hopes for a good Christmas and holiday season despite the circumstances. And speaking of that, I think this is the last occasion the commission will be together before the holidays. So to all out there, best wishes, Merry Christmas, Happy New Year, and make it most importantly, make it a safe holiday. And is there anything else? Anybody want to make any comments?
Chairman,
Commissioner
we did have one more.
Go ahead. Mr.
One more
Hardy.
item. Yeah, thank you. So our second item today was a cybersecurity update from Delmarva, which will require an executive session. And then we can invite Doug Moykoid from the company to update the commission.
Yes.
Okay, and that'll take me a second to establish a separate line for that. So I'll do that after you make your motion.
Well, we want to do a motion. It's my understanding we're going to go into executive session for a confidential briefing on cybersecurity. And so I need to have Commissioner Drexler make that motion.
So moved.
And is there a second, please?
I second it.
Any discussion? All those in favor signify by saying aye.
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 All five voted aye. The motion carries. Would those who are going to participate in the briefing come forward, and those who are going to not, please leave.
Commissioner Gray, I did forward you this number that we'll initiate here in a second.
Yes,
Okay.
I have it, Matt. I'll dial you in a second.
Thank you.
Wishing everyone a Merry Christmas and a Happy New Year.
Thank you. I think it would be highly appropriate for Mr. Slater to remain if he wishes to remain, mainly because obviously
Welcome to the conference center. Please
These
enter your
matters
moderator code
may
or your
come up
participant
for-
code, followed by the pound sign.
You want me to stay? Okay. All right, well, he says I can go. Do you say I can go?
I think he could brief you back very thoroughly.
Please wait while you are
You're welcome to